Hello everyone, this is Ryan with Ryan on the System. I'm an attorney, and on this channel, Ryan on the System, we talk about all things law, politics, and government, and all things the system. So today, I wanted to talk about three things that every California tenant should know. If you rent residential property in the state of California, you need to know these things going forward into 2023, 2024. They are very important to your lease agreement, and to your ability to stay in your property. So as everybody knows, the last 3 years have been the COVID years. A lot of major metropolitan areas and the state of California have enacted some form of eviction moratoria, some kind of law that protects tenants from being evicted for non-payment of rent and for other just causes. Landlords have gotten significant assistance, significant financial assistance from the state and from the federal government over the last couple of years to help them pay rent, but this has by no means given landlords the ability to pay all of their owed back rent from tenants. This subsidy has been moderate at best, and so landlords have not been able to recoup all of their losses. So, given this situation and the fact that there are quite a few tenants in California who still owe a significant amount of rent from the COVID period, which is the period from 2020, early 2020, March 2020, through the end of 2022, it's imperative for California tenants to know the following things. Number one, in most major metropolitan areas in California, the eviction moratoria that were put into effect at the beginning of COVID-19 in March 2020, those eviction moratoria are starting to expire. Case in point, in Oakland, California, the eviction moratorium that was in effect in the city of Oakland as opposed to the county of Alameda, which surrounds Oakland, this eviction moratorium is going to expire on July 15th, 2023. This eviction moratorium has essentially protected tenants in Oakland, tenants renting any residential real property in Oakland except for those exempt real properties that are exempt under the Oakland rent ordinance that was already in effect before COVID-19. It has prevented landlords from evicting tenants for any just cause, except for significant health and public safety concerns. If they can prove that the tenants are a threat to health and public safety, then they have been able to evict tenants for that reason, but that's been very rare. So in Oakland, landlords have not been able to evict for any just cause, including non-payment of rent, for the past almost 3 years. Now that's created a situation where you have some tenants in Oakland, and this applies to other major metropolitan areas around California too, some tenants that have not been able to pay rent for more than 2 years. And so they now have back rent that has accrued, and landlords have not been able to take eviction or unlawful detainer action against them. So that situation is coming to an end. Your landlord, if you live in a major metropolitan area, may be able to start eviction proceedings against you in the near future if you owe rent. And even if you don't owe rent, some of these eviction moratorium have prevented landlords from undertaking any just cause eviction against their tenants. So the landlords may now be able to pursue individual just cause evictions against tenants. It's important that you check your local jurisdiction, exactly where you're located, if there's a city or a county ordinance in place, and that you talk with a licensed attorney or someone to help you navigate all your options if you are served with any kind of notice to quit. So the second thing that all California tenants need to know is that even if you owe rent, if you owe back rent, if you owe even 2 years of back rent, there are still going to be some protections in place for you going forward. This applies on a city and county and statewide basis, but essentially, if you are a tenant in a major metropolitan area, most major metropolitan area eviction moratoria allow you to essentially, if you have documentation that shows that you weren't able to pay rent as a result of COVID-19, and you're able to present that in court in response to an eviction action, then that is an absolute defense against eviction. Obviously, you have to present evidence. You have to have the evidence. You have to have not just testimony, your own testimony, but documentation. You have to have receipts. You have to have notices of unemployment. You have to have notices that you have COVID-19, or that your increased childcare or increased costs or expenses were related to COVID-19. But if you present this in court in response to an eviction action that covers rent that came due in many cases before July of this year, and in some cases before the early part of 2022, then you may have a defense to an eviction. The third thing that all California tenants need to know going forward into 2023, 2024, is that your landlord has more than one option to pursue rent against you. Your landlord does not need to, your landlord needs to obviously go through the unlawful detainer process. They have to serve you with a notice to quit, a written notice to quit. They can't just come to you and say, you have to leave, please leave the unit, I need you to get out, and then you're required to get out. They have to give you a written notice to quit. They have to pursue lawful remedies. They have to serve you with a summons and complaint. They have to start an eviction action to dislodge you from a place. Unless you negotiate a buyout agreement with your landlord, and that's something different that we'll talk about a different day. But if you owe significant rent, the time is now for you to start negotiating with your landlord to either waive some of that back rent, or to reduce some of that back rent, or some kind of vacate agreement with your landlord so that they don't pursue rent in the future against you, depending on how much you have that you owe. It's a good time now to start negotiating. Obviously, you want to talk to someone, you want to talk to an attorney before you start that negotiation process. But now the time is good, because the incentives for landlords to negotiate with their tenants are coming to an end, given that they now have the option of pursuing evictions against tenants for non-payment of rent. And also, as landlords have had the option of pursuing a small claims action against tenants for unpaid rent below a certain threshold, and for a certain time period, but they've also always had the option of pursuing a civil case against tenants for non-payment of rent. So really, a negotiated resolution to rent is the best outcome for tenants. And depending on where you are, if you owe COVID-related debt that accrued from between March 2020 through the early part of 2022, and you want to have some of that rent waived because it's never actually going to be waived, and you want to negotiate some kind of a vacate agreement from your current premises, or you want to waive rent from the past so your landlord does not come after you for it in civil court, then now is the time to start negotiations there. Negotiations can be very effective to giving peace of mind to all involved. So those are the three things that all California tenants should know going forward in 2023, 2024. This has been Ryan on the System. Please like, subscribe, and share. We appreciate everything that folks say. Please comment, and if anyone has any questions or anything, please comment, like, subscribe, and share below. Thanks so much. Until the next one.